in 1710.
Hello, everyone. Welcome, welcome, welcome. We are so excited to have Ruth Benjamin here again with us. She's going to talk about something called 642. She's been in the business for about 30 years. She loves working with 1031 people and showing them how not to have to pay taxes. So Ruth, welcome. We are so glad you are here, and thank you so much for coming again, and please take it away.
All right, so let me get this slideshow started and share my screen. All right, so today we're talking about, we call it doing well by doing good. It's a legacy preservation system. And what it does is we have asset protection and tax mitigation. Just trying to get this to move over for me here. So we call it a family holdings trust paired with a private family foundation. So my name is Ruth Benjamin. I am a capital gains tax strategist. I have been the president of 2 different title company owned accommodator companies. But I'm currently the customer success manager of National 1031 Exchange Services. And I've spent probably the last 10 years now working with other strategies when 1031 is not always the best fit. So we are not providing or attempting to provide tax or legal advice by making this overview available to you, nor does the overview itself contain sufficient information to constitute tax or legal advice. So Nelson Rockefeller says it the best. The secret to success is to own nothing and control everything. So there's several problems in our life that creates tax problems. Problem number 1 is capital gains taxes. Problem number 2 is 1031 exchanges cause a lot of stress when you have to meet the timelines of 45 days, 180 days, you must buy equal or greater. If you had a loan on the property you sold, you got to have a new loan on the new one. So there's just a lot of problems that are coming up. Besides, they're trying to pass that a person can only defer $500,000 worth of gain per year per person. That's not happening yet, but that is one of the things they're trying to pass. And then income taxes, when you make investments and you get a great return on that investment, you know, those investments are great, but after you pay the tax on what you earned, it's not so great. So the problem number 4 is future tax hikes. So what we do is we check the Tax Foundation website for any updates on proposed tax laws. So what they're talking about is raising the capital gains rates from 20% to 28%. And then they want to take it to 39.6% on any of the gains over $1 million. They're talking about eliminating step up in basis. So if you pass away and you inherit or someone passes away and the family inherits the property, they're going to inherit it with the tax bill if they take away step up in basis. And then again, they want to cap the 1031 exchange benefit up to $500,000 per person in deferral of taxes. And they want to reduce the death estate tax from 11.58 to 3.5. But we do know in 2026 with the sunset clause, it's expected to drop around $6 million per person. So problem number 5 is not having solid asset protection. The first rule of tax planning is don't lose your assets. All the tax planning tools in the world will be useless to you if someone else can get a court order or judgment and take money from you. Problem number 6, corporations, S-corps, and LLCs don't protect you as well as you think. It's easy to pierce the corporate veil because they're tightly held entities. So if you don't have 35 members or more in your LLC, you are operating under your alter ego. So the courts claim that you are controlling the owner of the entity. So it's a very winnable argument if an attorney is fighting against you for their client to win the argument with the judge that says, hey, Even though these companies are under these people's names, it's still this person. So it's a coin flip to see if the judge is going to let the person get to just the one asset or all of the assets. So roughly 50% of entities can be pierced because they're not operating their business properly when it comes to the records, the meetings, and the minutes, if those records were pulled into court. So that is an easy way to pierce the corporate veil. So once you have your trust set up, it can be done, the other entities can be done away with. No more meetings, no more corporate minutes, and if it is determined that your corporation is not needed. In some cases, people do keep their corporations with these trust structures. So 39.34%, the state courts have pierced these entities. The federal courts have pierced 41.42%. So it is not a preferable way to hold properties. Problem number 7, insurance is only a partial solution. So it is not the solution. Umbrella insurance policies often do not cover punitive damages or gross negligence. So if you are at fault, there's a chance they're not going to cover everything. But we still want you to have insurance and umbrella policies, because if somebody does sue you and win, then they'll collect what the insurance company gives and not have to deal with the items that are in your trust. Problem number 8, filial responsibility statutes. So many states have filial responsibility statutes allowing long-term care facilities to seize the assets of adult children to cover unpaid bills of their parents. So if you're listed on these states, then you need to protect yourself. So if you have a parent in long-term care, their bills will not be carried to you. So there's a solution. We have a tax deferral and asset protection trust. We call it a family holdings trust. A family holding trust owns all of your stuff. And then we pair it with a private family foundation. So the first things to know is this trust is a non-grantor, irrevocable, complex, discretionary spendthrift trust. It is a dynasty trust. It carries on for your family. So once you pass away, your children could use it. Your grandchildren could use it. It's going to move for generations. Now, these trusts offer the best asset protection in the United States without going offshore. So this is a contract. These trusts are contract. They follow contract law. This contract is between the grantor, the person that sets up the trust, and the trustee, which would be you. So the contract, so the grantor creates the trust. The trustee will manage, invest, maintain the assets owned by the trust for the ultimate benefit of the beneficiaries. And the trust protector, whose main job is protecting the interest of the beneficiaries. So the main role is the trust protector. The trust protector's role is to act in a way that's comparable to a board of directors in a public company. So I always look at these trusts as they're your company. So it is the ultimate authority with respect to the operation of the trust after the grantor's tasks have been completed. Our clients always almost name themselves as the trust protector to ensure that ultimately they have complete and total control over the trust assets and decisions made with respect to the trustees and the beneficiaries. So the trust protector can add and or remove beneficiaries at any time. Okay, from time to time. They can remove a trustee or appoint a new trustee or a co-trustee. They can name, add, or replace successor trustees and successor trust protectors, and they can modify the whole trust agreement if they want to. So the first step is to create the trust. So an independent third-party grantor creates the trust to ensure the trust will be classified as a non-grantor trust and one that is not self-settled according to the IRS rules. So the person who creates your trust The grantor can be a family friend, a business associate, etc. So if you prefer that no one you know be made aware that the trust is being created, we can help you locate someone to act as the grantor. So in other words, the grantor of your trust can be any competent adult who will not ever be a trustee or a beneficiary of the trust. So this grantor will apply for an EIN number using their social security number. So the IRS will not even have your social security number connected to this trust. So then they're going to order the trust documents from the attorney's office, and they're going to write a check for a nominal sum to fund the trust. So typically we send $50 as a money order to fund the trust. So when the trust instrument, the contract, is received from the attorneys, the grantor who set up the trust will sign the trust, and those provisions turning over complete control of the trust to the trust protector and the trustee, and the provisions stating that the grantor is irrevocably forfeiting any right he or she might have ever had to change the terms of the trust. So that's the irrevocable portion of this trust, is that the grantor cannot come back to the trust after the assets are in it. The grantor cannot exercise any control over the trust assets. The grantor cannot demand the return of the money that they gifted to the trust to fund it. They will go away forever with respect to anything having to do with the trust itself or the property the trust owns. So by following the steps outlined, we can ensure that there will never be an instant in time during which your family's assets will be under the control of an independent third-party grantor. None of your family's assets will be transferred to the trust until after each and every right, power, privilege, and authority the independent third-party grantor once held with respect to the terms of the trust and to its assets has been permanently and irrevocably forfeited by that grantor. Remember, the grantor cannot even get the $50 back they contributed to fund the trust. So now you're going to go to step 2, where you're transferring the assets to the trust. So neither you nor anyone who might ever be a trust protector, a trustee or co-trustee, or a beneficiary of the trust should ever gift an asset to the trust. Gifts to the trust from any of those people could cause the trust to be reclassified as a grantor trust. Only trusts properly classified as non-grantor trust can provide the asset protection and tax mitigation benefits we have been discussing. So instead of gifting the assets to the trust, you will sell them to the trust. So the trust pays for the assets it purchases from you and perhaps from any of the family members by issuing a demand note. A demand note is a legal obligation of the trust. Interest is included and required by the applicable federal rate. And today, I think it's about 4.5% is the applicable federal rate. Back, last year, it would have been less than 1%. And the interest rate changes, has to be updated every 6 months when you're using demand notes. So payments are only made upon the demand of the holder of the note. So there are not necessarily monthly payment requirements. And the demand note is non-transferable, so it cannot be reached by a creditor. So now we need to live within this trust. So instead of living out of your personal checking account, you want to live out of this trust checking account. So when you use the debit card or you write a check, you sign your name as your name, comma, trustee. When you're acting in your official capacity as a trustee, you pay for functionally everything you buy with a debit card tied to the trust checking account. So we can discuss valid trust expenses and demand note principles later at the end of this, but it keeps these payments from being taxed to a beneficiary or a trustee. Keep your receipts for everything the trust pays for. You would do this if you owned a business. And like I said, this trust is like your business. So you could justify the information you report on the tax returns. So that's really all the difference that's different from the way you live your day-to-day life. So if you keep your tax records in Excel worksheets or QuickBooks, Quicken, or any type of app like that, keep using that. But if you're not sure to get set up on QuickBooks or anything like that, we can help you. And if you're currently keeping your records in a shoebox, we need to help you start putting these into some type of app that will help you with this. So your CPA, enrolled agent, bookkeeper, or other paid professional will prepare the trust federal form 1041. And of course, if you're in a state, we got to file state taxes, they'll form that one too. They will also update the trust financial statement at least annually. So you as the trustee, you can sell any assets owned by the trust. You can purchase assets in the name of the trust. You can borrow money in the name of the trust, secured by the trust-owned assets. You can lease vehicles and or equipment. You can lease property to tenants of trust-owned assets. And you can buy and trade EFTs, exchange-traded funds, public securities, cryptocurrencies, interest in syndications, etc., and virtually anything else you can do as an individual. You can also sell intellectual property to your trust. That's copyrights, trademarks, software that you've developed, manuals you developed, anything in the operation of your business. This gives more protection than trademarks or copyrights can do alone. Okay, so you would receive distributions from a separate business trust created to be and become the owner operator of an unlimited number of autonomous companies without having to pay annual state registration or tax return prep fees for each company, as are required if your planning approach is based on series LLCs. So you would put everything into one trust, one tax return, no state fees every year to keep the LLCs going. So you enter into transactions such as the following in the name of the trust to get long-term, even permanent deferral or elimination of capital gains taxes, sales of companies, real estate, or other appreciated assets, but not securities issued by public companies. You own now you're going to sell it now to the trust using 25 or 30-year interest-only installment notes. That's IRS Code Section 453. Now, this method requires post-sale hold by the trust for 2 years and a day. So I'll explain that one in just a couple slides on how that's going to work. So now we talk about the private family foundation that eliminates the tax bills. So in the case of the trust, not a simple trust, ours is a complex trust, and it earns income. The trust can deduct the full amount of the income it gives away for charitable purposes from its taxable income. So this means it won't have to pay taxes on any of the money it donates to charities. Also, if the trust makes a charitable donation after the end of the taxable year, but before the last day of the following year, it can choose to count that donation as if it was made the first taxable year. This way, it can still get the tax deduction for that donation earlier in the year. So if you're making a donation for last year's taxes, you have till the end of this year, December 31st, to actually make that donation when you're using these trusts, these non-grantor trusts. So if an individual, an LLC or corporation gives money to qualified charities, they can deduct that amount from their taxes. Usually there are limits from 20 to 60% on how much they can deduct. If the non-grantor trust, which is the family holdings trust, gives charitable donations, they can deduct the full amount of those donations without limits. And they have until December 31st of the following year to make that donation. Also, they can claim this deduction even if the charity they donate to is located outside of the United States or US territory. So it doesn't matter where the charity is based, they can still get the tax deduction if it meets the qualifying criteria. And what I like about this foundation also is if you have a family that they're in the neighborhood, their house burns down, you can Go get your debit card from your foundation checking account. Go buy the family coats and jackets and blankets and water, whatever they need, and give it to them. So it allows you more flexibility with these funds. Now, once you have the money sitting in the foundation to eliminate tax bills, there's rules to the foundations. And what that is 5% of the foundation's assets per year have to be given to a true charity. St. Jude, your church, Red Cross, Wounded Warriors, your favorite dog shelter, any true 501c3, or you can put on a charitable event. So I have a business partner who has an autistic grandson. So every year he puts on an event for 25 autistic children and horses. He brings the families in. He gives everybody t-shirts, feeds them all, and his daughter runs the event. That goes towards that 5%. Now, the rest of the money in your foundation, anything that is 95% passive or more, your foundation can partner with you. So let's say you want to buy a piece of investment real estate and you need 30% down payment. Your foundation can come up with the 30% cash and you would be the 70% owner. So your foundation would get 30% of the rental income. And if you ever sold that property, your foundation would get 30% of the sale and you can keep doing this. Now, nobody in your lineage can benefit from foundation money. They can benefit from the family holdings trust money, but the foundation money has to be truly used outside of your family. But there are ways, and believe it or not, brothers and sisters and cousins are not considered part of your family. So you can always loan money to them or give grants to them. So neither the family holdings trust nor the business trust are simple trusts, they're complex trust. Therefore, contributions from the taxable income of the family holdings or business trust to a private family foundation are fully deductible. Charitable contributions made by corporations, LLC, and individuals are limited to 20 to 60% of their adjusted gross income. And subject to a standard of reasonableness, a grant-making private family foundation, that's what we create, can legally employ family members as directors or trustees, and subject to prescribed limits, can invest as a non-voting equity holder in a for-profit business. So asset protection isn't about making you suit-proof. Anybody can sue you for anything with or without merit. Instead, real estate asset protection is about giving you, as the trustee, the legal leverage to control. So when, if, and how much a lawsuit against trust-owned assets, a beneficiary or trustee gets settled. Even if you lose the lawsuit, your new creditor is granted a judgment and a charging order, they still will not be able to collect because the contract says the trustee can only give money to beneficiaries. And this person who sues you is not a beneficiary. If you want to give them a little bit of money, you could go to your trust book, make them a beneficiary, write a check to them, and then go back to your trust book and take them out if you feel that that is important to you. So the asset protection we claim our trust can provide is rooted in the fact that a common law trust such as ours is a contract between the grantor and the trustee. Spendthrift provisions contained in the trust instrument are an essential part of the contract. Sections of the legal codes of the United States that are applicable specifically to non-grantor trusts prevent courts from breaching that contract by requiring the trustee to distribute income or principal to anyone who is not a beneficiary of the trust. Ever heard of the saying, you can steal more money with a briefcase than you can a gun? You could protect more money with a briefcase than you can with the gun if your briefcase has the right papers in it. So let's go over the final pieces of this puzzle. A reminder that this family holdings trust is a dynasty trust, meaning that it is designed to provide benefits to your family for generations. It does need to be renewed every 20 years, no cost to renew it. You don't have to pay any copyright holder fees or any state or federal government fees. There is no annual report to be filed with the Secretary of State or the Franchise Tax Board, and nothing to do to say that you're going to keep the trust in good standing. You don't have to file any of that. And in most cases, you won't need any LLCs or corporations you currently have once your assets and companies have been transferred to the trust. So if you have a Wyoming LLC, you'll save $52 a year. If you have a California LLC, you'll save $800 per year. Now, once your properties are in your trust can do 1031 exchanges. Your trust can do tax deferred cash out or Delaware statutory trust. They could do opportunity zones. They could do angel or other venture capital investments in Section 1202, small business stock, and other tax planning tools that provide long-term, even permanent deferral or elimination of capital gains taxes. So let's take a look at this strategy for people that own real estate. Okay, you sell your property to your family holdings trust, the non-grantor trust, at fair market value on a 30-year installment contract, interest only. So the day you bought the property up to 2023, let's say we're doing that, all those gains are locked up in your installment contract. After 2 years and 1 day, that your non-grantor trust, your family holdings trust, has held that property, it can now sell to an outside third-party buyer. So all the sales proceeds from that sale go into the non-grantor family holdings trust checking account. So the family holdings trust will have a taxable event for the 2 years of gains that it held the property. So the family holdings trust will donate the 2 years of gain into your own private family foundation, and you have wiped out 100% of the capital gains taxes. You deferred a lot of it for 30 years under the installment contract, and you wiped out the 2 years of gain by giving it to your foundation. So a lot of way that people are taking care of the tax bill 30 years from now is using life insurance. So that's what a lot of the clients do. But pretty much you don't have to do life insurance, but it is one option to help pay the tax bill 30 years from now. So remember, the foundation must give 5% of the assets of the foundation donated to a true charity, or you can put on your own event. And like I said before, the foundation can partner with you to come up with the cash to buy any investment property, not a primary residence, and then any rental, if it comes up with 30%, the rental income has to go to the foundation. And if you ever sell that property, the 30% would have to go to the foundation. Okay, so you have to make sure the numbers are set up. So if you wanted to get more information, you would just have to schedule a consultation with me, and then we would move forward to set up the EIN and get your trust documents set up for you. And here is my number if you want to have any more information.
Thank you very, 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 very much.
You're welcome.
This was
Anybody
very,
have any
very good.
questions?
And of course, I have lots of questions, and a lot of them will happen offline, but I do have a few online. So if you've all got the number, and if you do want to talk to Ruth, just let me know and I'll do an introduction, email introduction, and that'll have a little more weight.
Yeah.
So if you'd stop sharing so we could see
Yep.
everybody.
Okay,
That's
good.
great.
I was waiting
Thank
for
you.
you to
That
tell
was really great. I really thank you. I'm starting to understand it more and more. I know it's a little complicated. I've worked with trusts for years. I actually was a trustee for many years on some these kind of trusts, but not in the sense of how you explained it. We didn't do any of those kinds of things. We just didn't know enough. And nobody talked about these kinds of trusts. And I know they were around at the time.
Mhm.
So besides me, does anyone have any questions? I can hold mine till later. No. Oh, Jana, trust girl, ask away.
All right, my question relates to pre-tax assets like 401ks, traditional IRAs. So if you sell those to your trust and you put them in trust, how are the taxes handled?
You typically, if they're already receiving a tax benefit, those are items you would not want to put into the trust, because removing them from your name as an individual and the tax benefits by moving it, because remember, this non-grantor trust is a completely separate entity. So you would not want to move those into the trust. But if you had the trust and now you're going to buy in, or you're going to do a 401, an IRA, then you would want to do that IRA under the name of the trust. But anything that you have existing, you wouldn't want to move it because it would create a taxable event.
Oh, so if you take your regular traditional IRA and sold it to the,
Trust, it would be a taxable event. Because remember, the
still would be.
trust is a completely separate entity. This is not you. This is the whole theory of you don't own anything, you control everything.
Okay, so if you created it in the trust,
Right.
then the taxes are an expense of the trust?
The taxes would be contributed to the trust. Then the taxable event, you would donate to your private family foundation and you wipe out the tax bill.
Interesting.
but if you've already got a traditional IRA, you're saying you can't do that.
You wouldn't want to, unless you had just
Why?
created
You owe all
it.
those taxes. If you have $1 million today, you owe taxes on $1 million when you start pulling it out. Or
Well, you could move it and then move make a donation to your foundation and wipe it out. But everybody's circumstances are going to be different. So we would look at each client and say, okay, yeah, let's go ahead and move this because it's a benefit to you. Or, maybe if you have some carry forward losses, you could now move something that has a taxable event and offset the losses. So it really depends on each client's goals, and we connect you to the tax advisors and the attorneys to make sure that your goals are met when your trust is structured.
so if you have a foundation, could you donate your traditional IRA to the foundation
Sure.
and avoid taxes that way?
Yep. But now your money is locked up in the foundation, which you cannot use yourself, but you can use it for if you want to buy investment properties or you want to support charities in that. So there's a lot of different reasons people do that. We had one client that donated his whole real estate, one house that he donated to the foundation just because he didn't want to pay any taxes on it. So, and then now he's using the money to go ahead and go flip and buy other properties. So it really depends on each person's goal.
And all of that goes back to the foundation.
Mm-hmm.
Because it's held in the foundation. So the foundation could grow, which I always think is a good idea anyway. Instead of having to go out and raise money, you're using the foundation money to invest to make more money. So the foundation could grow without donations.
Correct.
So there's that side of it. And then if you take a fee, you have to pay, if you are the trustee or the foundation, whatever that, you have to pay an income tax on that fee, of course, because now you're taking income. But the foundation, all the income from that foundation still just goes back tax-free to the foundation.
Right.
So you have to look at what your family goals are for that IRA money.
Exactly.
What's the ultimate goal and how do you meet that ultimate goal?
Mm-hmm. So we have, several times we talk to clients and they say, I don't have any children. I don't have a spouse. I don't like my nieces and nephews very well because I don't like the way they're treating my brother or sister. And they're going to give to charity anyway. Well, that client, if they're going to give to charity anyway, you can get the 401k out, put it in your foundation and give it to charity. So it's, like I said, it really depends on each client and their goals.
Okay, one more question.
Yeah, go ahead, John.
So the other question comes into long-term care eligibility for things like Medicare, and how are the assets in this trust viewed from that light?
They're separate. So, and the reason I know, I own these trusts, and my husband was looking at retiring, so we were going to have to go on Covered California for medical. And they basically told us, you make too much money. I said, okay, how much money do we have to make? Personally, So you can shift your income to your trust and have your personal income what you need it to be in order to benefit for some of the products that you need.
And does
So
that
you're
get
in control.
around?
You're in
Does it-
control.
So does that get around, what did you call it, where the kids can be the
Filial responsibilities.
Does that dodge the filial responsibilities?
Well, it doesn't affect it in any way because, well, in order for your children not to be affected by the filial responsibilities, we need to create a trust for them. And I have done that for my children. I mean, I don't ever plan on going into a long-term care home, but whoever plans it, right? But yes, you would want your children to have their own trusts.
But the benefits, if they're beneficiaries of my trust, are they protected on as beneficiaries?
Your
on my
trust assets are protected, but they're not protected. See what I mean? We would need to have them have a trust also. So another thing, because I have 7 daughters, and these trusts are great alternatives to prenups. So I have daughters that own houses before they met their fiancés or significant others. And I said, put these properties into your trust because your trust owns it, you don't. So if they ever got divorced for any reason, the spouse would not get anything because the trust owns it. My daughter doesn't. Do you see what I mean? So it really protects the children when it comes to that, and anybody.
And I'm assuming you can't then, that these need to be in place before you need long-term care.
Yeah, you need to have the trust in place before, you're right, because if they look back, you know, they're going to be checking your bank statements and that. So yeah, you need a plan. You can't be just a reaction.
Yeah, and is that a 2-year look back?
The last I heard, it was 3 years look back, but I'm not certain. I'm not a specialist in that.
Thank you.
Mm-hmm.
Great, thank you, Jonna. Cliff.
So I noticed in one of the slides that you stated that you might be required to buy additional insurance. So if the trust provides asset protection, why is additional insurance necessary?
Well, I don't remember a slide seeing you needed additional insurance. I talked about
suggested it.
umbrella policies.
Right.
And, you know, we don't want you to get rid of your current insurance or umbrella policies. You know, we're not in the business of making the insurance companies out of business. But if someone does sue you and they cannot get to your assets in your trust, well, at least maybe they might go away with the amount that the insurance company gives them, but they're not going to be able to touch your assets.
Kind of like a honeypot. It draws them into it and they'll say, okay, I'm satisfied, and then move along.
Right. And
Okay.
even if they're not satisfied, they're not going to get anything out of the trust. And once an attorney realizes all the assets are sitting in this trust, they're going to ask the client for upfront fees to defend them. And typically that's not going to happen. And they're
I
not
would
going to
figure
win.
They
Yeah.
would know that pretty early on discovery. I mean, they
Right.
would know that they're not going to be able to pull assets out of it and, you know, be like the Jedi mind trick, move along, nothing to see here.
Yeah, one of the clients that my business partner has worked with quite a few years ago, back in the 90s, he was sued by the state of Maryland. And the state of Maryland went to court 3 times to try to get to his assets that were held in his trust, and they lost every time.
Mm.
He still owes Maryland $100,000, plus I'm sure quite a bit of interest. But he hasn't been worried. Now he's a business owner. He's got like 40 doors, and he's just not worried about giving Maryland that $100,000.
Next question, is the trust protector the same thing as a compliance officer in this trust?
I'm not really sure of the role of the compliance officer, but
Basically
I'm
sounds like what you
thinking,
described as a trust protector, but I've never heard trust protector as a legal term, but I have heard compliance officer. So I was just trying to make sure I understand for clarity.
yep, I would say it's going to be the same thing, compliance
Okay.
officer and trust protector.
The trust is irrevocable, right?
Mhm.
Now, I believe I heard you say that the trust protector can make any necessary changes to the trust, but if it's irrevocable, how can they do that?
The irrevocable portion is only the portion where the grantor sets up the trust and the grantor removes themselves. And they literally sign the trust and have it notarized that they're irrevocably being removed from the trust. So that's the only irrevocable portion.
Okay. And how do you suggest a property title be transferred into this trust? And how does that work during closing?
Are you talking about you're buying a piece of property and you want to put it into the trust?
Well,
So it really,
either way, if you buy a piece of property and put it in the trust, or if you have an existing property and you want to move that title into the trust, what's the
Okay.
process for those?
so if you have an existing property, you want to sell it to the trust on an installment sale, interest only for 30 years. If the trust has if the property has a loan on it, you want to assign the loan to the trust. If you're worried about a due on sale clause, and it depends on state to state, right? Every state has different rules, but if possible, some clients do not record the deed because they don't want to worry about property taxes. Here in California, you need to be a beneficiary. When the property's transferred to the non-grantor trust, if you're a beneficiary of the trust, not the trustee, not the trust protector, then California allows you to make that happen without being reassessed on property taxes. So it really depends on what state you're located in and how they're going to handle that.
So what am I doing to actually transfer the title into the trust?
A deed.
A
You're
grant.
selling
Just a
it.
deed?
A
So
grant
I can
deed.
just take my deed and put it in the trust and say that it's now in the trust? I don't have to do anything else?
Has to be recorded.
Yeah, you're going to record it unless for some reason you don't want to record it, because California recognizes that a deed is valid without being recorded. And I think it's Missouri, maybe they don't. If it's not recorded, they won't recognize it. But
Okay.
California, you don't have to have it recorded because people are worried about due on sale, because if the lender finds that the property is transferred, there is risk of due on sale clause. But over the last 41 years that my business partner has been doing this, he has never run into due on sale. But that's why we talk to each client individually and see where your comfort zone is and how you want to handle your transaction.
How do I obtain a credit card with the trust?
Just like business credit cards, you would use the trust as a business.
Okay, very good. And just to clarify, this trust does not require you to pay state taxes, or it does require you to pay state taxes?
The trust, you will pay tax. If you pay taxes as an individual and you live in a state that you have to pay state, you have to pay tax. If you don't live in the, if you live in a zero state, you don't have to worry about it. But the trust structure itself, you're going to pay taxes just as if you were an individual. It's the foundation that helps with the tax mitigation.
Okay. And last question, what attorney's opinion letter can you provide that supports this trust?
We have probably right now, we have Hawaii, Texas, California. We have a few different states where we do have the option to have our clients get an opinion letter. Opinion letters are not shared for the fact that the clients cannot even share them with us. Otherwise, it invalidates the actual opinion letter. So it's not something that we could say, oh, this client got one and here's the opinion letter. So it's really so private that I don't even think the CPAs can even see it. You know what I mean? It's something between the attorney and the client. So no, we don't have any sample opinion letters. We do have attorneys that clients can speak to and that can back this structure, but we don't have any opinion letters to share.
I'm curious about that because I have seen other trusts where they do openly share opinion letters based on
Yeah.
their trust. So
Absolutely.
why is it different?
Well, I don't want to get into other trust companies versus us. All I can tell you is if an opinion letter is shared, it is no longer valid.
Okay.
Okay. All right. That's all the questions I have.
Thank you very much, Nika.
I think I know the answer to this, but I'm more asking because it came up in a conversation. Kind kind of like how you talked about the prenuptial agreement. Is there any way to do it if you're preparing for a divorce? You can't put things in a trust because to protect them from the divorce while you're still married, can you?
I know. Well, what you can do is before a
Someone asked
divorce,
me.
you can separate things and have an agreement that that's how it's separated using these trust structures. So then when you
Yeah.
get divorced, it's going to be easier. But I just, because I have 7 daughters, I'm just like, look, just get your properties in the trust and, love your spouse. I don't ever want you to get divorced, but I don't want your spouse to be able to take it away from you, especially if you bought it before you were married.
Yeah, exactly.
You know what I mean?
Yeah.
I'm not saying whatever you grew together that you're not going to give to them. No, I'm talking about anything that was bought prior to marriage.
Yeah. All right.
But I did
I
talk to a
know the answer
client
to that, but
yesterday. He's
just
a
thought I'd
stunt
ask.
guy. He's a stunt guy in Hollywood. And he's like, I'm getting divorced. I'm like, you talked to me just a little bit too late. We need to get these things set up.
Okay. Anything else, Nika? Tracy,
No.
nice to see you.
Thank you. Ruth, wow, that was just like a fire hose of information. Thank you so much.
You're welcome.
So I'm a real estate agent and I'm a senior real estate specialist, and I have a lot of conversations with people about Prop 19 and the reassessment of their property for their heirs. So I'm sure you're very, very familiar with that. What can this help people pass down, say, like legacy property? Because I hear all the time, well, we have, a property that great grandpa built up in Lake Tahoe, and we want to pass it down and not have it to be reassessed. Can it help with that?
Yeah, absolutely. So this is the beautiful thing about these trusts. You get everything into the trust name. So when the grandpa passes, the trust didn't die, nothing changes, property taxes don't change. A lot of people, the whole part about, you have mom's house, and if you don't move into it, you get reassessed property taxes. People are having to sell these properties because the taxes are too high for them to keep it. And they would love to keep their childhood home, but they can't. So this trust will help with that. And the mansion tax in LA, the only way we found to get around the mansion tax is to donate the property to your foundation to get around that mansion tax. So that's kind of a crazy one too.
This is amazing, because let me tell you, I do seminars on this. And one of the things, Prop 19 is just really something I've always been, I didn't know about this kind of trust. So I've been really drilling it into people, how important it is to have a trust, but I didn't know about this. So I'm going to need to get a lot more information from you so I can give people better information. Thank you.
Awesome. Thank you.
I'll be reaching out to your email.
Okay. Thank you.
Thank you.
And I had a couple of questions, and now Tracy brought that up. It's like a LLC doesn't die either, and the taxes won't change on it either. And I don't know that it ever has to expire, but you do have to pay that $800 a year on it.
Yeah, and an LLC typically flows to your personal tax return.
That's true. Yes.
So that's the difference of the non-grantor versus your LLC and that.
Exactly. The other was, you said if you were at fault, your insurance wouldn't pay. So
Punitive damages.
yeah, what would put you at fault on so who's
if you ran a red light and you hit somebody.
okay.
Ask your insurance company. We had people one time, we made a challenge. We said, call your insurance company. If you were at fault, what would you end up paying and what would they cover? And, I belong to the local real estate board, and we just had a big seminar about a month ago, maybe. And they talked about how a lot of the insurance companies are leaving California. They don't even want to insure anybody. So insurance is going to be really tough. Right? Tracy's shaking her head. She must be running into that too.
Oh yeah. Yeah. State Farm pulled out, and another big one, Farmers, I think, pulled out. So getting like a lot of the properties around here in Ventura, because we have the fires that come through, the new buyers are having to go through the state run insurance, and it's a nightmare.
Exactly. So I always said, from that meeting forward, I'm like, okay, real estate agents, make sure you can get fire insurance before you get them pre-qualified. Even people that
Oh.
have been insured for 30 years on their home are losing their insurance.
That's right.
It's not just here that's happening, it's happening in Florida too. Actually,
Mhm.
I heard someplace else it was happening, another state it was happening, but yeah, and now
Te-
what happens in Hawaii?
Right.
Texas.
And Florida because of hurricanes. You better have a new roof on it or they're not going to insure it.
Right. Okay, well, we're almost at the top of the hour and here's Fred.
Hi, Fred.
Hi. I was wondering, is there some minimum amount necessary to transfer into the trust? I mean, either, in writing or in practical?
No, the trust cost basically for the family holdings trust and the foundation, the average cost is $35,000. If you add a business trust, then it takes it to $45,000. Well, we have a lot of clients that maybe just have their primary residence and maybe one rental house. And we have a trust, we call it the Light Trust. It's an estate builder trust. So you still get the tax benefits in that. The only difference is there's a trusted advisor instead of a trust protector, and you can add beneficiaries, you just cannot remove them. So that trust is $10,000, but the one that I talked about today is $35,000 for the foundation and the family holdings trust. So it really depends on your needs.
Okay, thank you. Oh, another one? Do you have another question, Fred?
That's okay if we're out of time. It
Well,
wasn't,
we'll get two more people that are gonna ask and we're
Go
not
ahead,
gonna
Fred.
cut them off, so ask
I
me.
just, sure, I just wondered, are there any restrictions at all on what the trust assets or funds can be used for?
No restriction whatsoever. But remember, when you're talking about tax write-off versus what you can spend the money on are two different things. So when you're living through your trust, whatever you can write off as an individual, you can write off with the trust. Okay, so we're not saying that the trust money, paying mortgages or paying college funds or any of that, and that is not tax-free. You have to use the foundation to offset the tax bill.
Okay. Got it.
Thank you. Cliff, and then Tracy.
Two quick questions. So if I took a vacation, how would the vacation be managed in the trust? A personal vacation?
Yep. So when you sell a property to the trust, you have a demand note. So if you want to take a personal vacation, you take money from the trust checking account and offset it with the demand note.
Gotcha. Okay. And then last question, what's the longest period of time I can defer taxes with this structure?
Well, this is not about okay, if you sell your property to your trust, you're going to put it on a 30-year installment contract. And if
That'd
the
be the
people
longest for the
are
property?
young, if the people are young, we could do 40 years if they're
Okay.
young. Okay, so that's how long you can defer the gain from the day you opened it, from the day you bought the property to 2023, it's 30 to 40-year tax deferral. The 2 years that the trust owns it and then sells it, that 2-year gain is put into the private family foundation and you've eliminated, not deferred it, you eliminate the tax
By going through the foundation.
by using the foundation, yeah.
But then you share 5% going out and 30% coming back?
Well, you have to give 5% out. The rest of the money can sit in the foundation's account. The
Right.
foundation can make investments and all that. But if you want to buy real estate and we need 30% down, then the foundation needs to get 30% benefit of the rental income and any sales profit back to the foundation.
Okay. Thank you.
Tracy?
Just a quick follow-up on the Prop 19 conversation, since you mentioned the estate builder trust, which is kind of the light version with the foundation. You said that's $10,000 to establish roughly.
Mhm.
Does that also protect them from that Prop 19 nightmare?
Yes, it does.
You have no idea how many problems you've solved for me. It's amazing.
It does.
Okay, awesome.
Okay. Wow. Perfect timing, y'all. That's at the top of the hour. And Ruth, thank you very much for coming on. I have to tell you this, a fire hose, as Tracy put it, lots of information, trying to understanding it. And really, if you have questions, you want to understand it better, let me know and I'll do an introduction to Ruth and she'll set up a time to have a conversation with you. And if you've got clients that want to learn about this, let's send your clients there. Let's help them get what they need like that. And Ted, I'll get that information to you that you asked
Nikki,
for.
will we be able to rewatch this?
Yes, we send, what we do is we go through and we put it together and then we send it out. We send everything back out. You know how you got the invitation? You'll get the record. You'll get the link to the YouTube recording.
Awesome. Thank you.
Thank you. Yeah, you'll have to watch this 6 or 8 times. So
Right. Exactly.
It is. It's one of those, every tax strategy I learn, I have to go over it